All right. All righty. Let's just make sure we're live on my end. Okay. Let me see. Okay, it's not showing that I'm live on my end. But anyway, so we just want to make sure we're live tonight. Thank you guys for joining us. If you are jumping on tonight on this lovely Sunday, I just want to check as usual, but my computer is acting wonky now. So we're just going to pray that we are live. But I know we are.
Click on those and find out.
Okay. It's sitting right in there live, so we should be good. Let me see.
Oh yeah, we are.
All right, perfect. Yep. So I always want to just double check just to make sure we're live and people can come in and have a conversation. Again, we have Whitney here. Whitney Knox Lee, Esquire. He is. I don't know why I'm saying Whitley. I don't know why. I didn't watch. What's the name of that? What's that show called? I forget. But anyway, sorry, I apologize. But we have Whitney here tonight with us. She's back by popular demand to talk about probate, POAs, particularly trying to give some emphasis around the power of attorney because we didn't get to hit on that last time, wills and trusts and things like that, and why you should have these particular things in place if you don't, because it could possibly end in total chaos when somebody might pass away or things may happen. So we'll have you introduce yourself, Whitney, and we'll kind of just jump into it.
Awesome. Thank you. I am glad to be back. We had a great conversation a couple of weeks ago. And if you did not have a chance to listen, I encourage you to go back a few videos in Devon's little playlist or whatever you want to call it to watch that because that'll be a good base, kind of like a good foundation, if you will, for this conversation. But anyways, I am glad to be here. My name is Whitney. I am the founding attorney for Wills for the People. I run a estate planning and probate legal practice in Atlanta. And I serve people throughout Georgia who need either estate planning or help with strategizing around some kind of inheritance that they may have received or are planning to receive, or how they may want to strategize around leaving assets for their loved ones. And then also after someone has passed away, I step in to help the family navigate the legal process that will come after somebody has passed away. So that is what I am all about. And I am, again, just happy to be here. Thanks for having me.
Yeah, no problem. So at the end of the show, or if you guys are watching this later on, Whitney's information will be below if you want to connect with her. And we'll also put her email up on the screen too, but we'll make sure that's down inside the show notes below. And then, of course, if you're live with us tonight, don't be scared to jump into the chat, ask some questions, engage in conversation. That's the purpose of us doing these lives, and actually being able to sit here and talk to Whitney is a blessing to all of us. So let's see. My dad said, "Hey, hello, everyone. Hey, how you doing?"
Hey, Mr. Clark.
David Matney
nice
joining us. Hey, David, thanks for jumping on again. And so we are going to just start off. So last time we kind of left off, we didn't get to jump into it about a POA, which is the power of attorney. David said, "Hey, Whitney." Hello, Whitney.
Hey.
And so, hey, what's going on, Corey West? Thanks for joining us. I know he had popular demand. He wanted Whitney to come back. So Whitney's here. She's here, Corey.
I'm here.
So we kind of ended when we didn't really get to jump into the POA. So would you be able to tell people exactly what is power of attorney first?
Yeah. So here in the United States, we are considered autonomous beings at the point in which we turn 18. That is when we are an adult. And at that point, other people stop making decisions for us and we start making decisions for ourselves, except for, of course, like drinking alcohol and renting cars. Everything else, we are making decisions for ourselves. And so what that means is we have to authorize somebody else to make decisions for us if we want that to happen. Otherwise, they're not going to have the authority to do so. And there are several ways to do that. The easiest, the most straightforward, the best, the proactive way to do that is through creating power of attorney documents. And so these are forms that you complete that is going to authorize somebody to make certain types of decisions on your behalf. In Georgia, the most common titles for these types of documents are just like power of attorney. Usually when somebody says that, they're referring to a financial power of attorney that is dealing primarily with somebody's finances. You might hear the term durable power of attorney or a general power of attorney. Those are kind of used interchangeably, but they also usually are focused on finances and real estate as opposed to the healthcare power of attorney. I use that term, healthcare power of attorney, but it's also called an advance directive for healthcare. And within that document, you have your living will provisions. And so other states might have a separate living will. The living will talks about what do you want to happen if you are in a terminal condition, you're going to pass away soon, or if you are in a permanent coma. It's asking you, do you want life support? And if so, like how much? How much life support do you want? And so that is the healthcare power of attorney, aka advance directive, aka living will. And in that document here in Georgia, it's kind of a combined advance directive and living will, where you are discussing organ donation, you're discussing body donation to medical study, you are saying whether or not you want to be buried or cremated or something else. You're talking about life support in these very specific instances. And then you are also talking about if you're somebody who's carrying a baby, what happens if something happens to you and your fetus is viable versus not viable, what should happen. And so those are the primary decisions. You're also able to talk about at the end of your life, what do you want that to be like? Do you want to, I don't know, be visited by a religious clergy person? Do you want to pass away peacefully at home, surrounded by family? Those types of things. You're also able to say, I don't want blood transfusions at the end of my life, or I don't want certain products used in my medical care. And so what those two documents do is you are naming the person who is going to be directing your doctors or your financial institutions based on what the wishes that you have made known to that person. Okay. And so as far as language is concerned, the person who you have given the authority to make decisions for you, if you can't, that person is called the agent. Okay. So that is my husband is my agent under my power of attorney. The actual documents are the power of attorney documents. And then the person making the document, I am referred to as the principal. Okay. So that's those are the two main ones. Oh, but I'll say here in Georgia, we also have the psychiatric power of attorney, which is a longer form that is for people with psychiatric illnesses who have periods of decompensation, maybe psychotic episodes where they cannot care for themselves. What they are doing is before they have one of those episodes, they're completing one of these forms that tells their agent everything from like, these are the medications that I would want. These are the medications that I do not want. I am consenting to involuntary hospitalization, or I'm not consenting, or this is how you should handle me. It's basically giving that person the power ahead of time to be able to make decisions later
later on
if they need it.
Okay. Corey said millions. Thanks to Whitney. Yes, thank you to Whitney for joining us again.
Yeah, absolutely.
MHOA said hola everyone, and then Angela said hello. And I'm gonna get to my dad's question. So with the POA, so we can wrap up the POA before we jump over to the living will and trust. So with the POA, and even in regards to the medical one that you were kind of saying as far as putting those documents in place, because I know my mom had mentioned that before too. So say if that wasn't in place, would I be as a child to a parent to say, if they're on life support, would I be able to say take them off of it, or should I have those documents in place to be able to do so?
Yeah, you may. And there are other things that might happen. So, like some
Okay.
medical professionals use the DNR language that we see
Okay.
in Grey's Anatomy.
Okay.
And so, like a doctor may ask somebody specifically, like, "Do you want to be resuscitated if something happens after this surgery or something like that?"
Okay.
Um, but I'm glad you asked because there's sort of maybe
Okay.
my in like out there in the world they're
Mhm.
not supposed to doctors and financial institutions are not supposed to take direction from people who are not your agent. But in like
Mhm.
real life, they do.
Mhm.
And so medical professionals are going to turn to the quote next of kin
Okay.
to help make the determination around life support,
Okay.
specifically. And you've seen, I'm sure you've heard about where they've come to a family member, and now the family member has to make a decision. The family member
Mhm.
does not know what that person would have wanted,
Mhm.
because maybe there's been no communication, no pre planning for this type of event. And so they're living with this decision now that they've made around whether or not to keep somebody on life support or
Mhm.
what kind of treatment somebody should receive. So I think practically speaking, a power of attorney is just it's a really helpful tool, not only for yourself to help people
Mhm.
know what you want to happen if you cannot communicate about the care
Mhm.
that you want, but also for the people that are now having to make the decisions, your loved ones who are grappling with, I'm making a literal life or death situation regarding this
Mhm.
person. Um, Being able to give them guidance means that they don't have to, hold on to some idea of, now this person is dead because of me. What if I would have just let them be on this machine for another 2 days?
Yeah.
So that's something that I wanna say, but the other thing that I really wanna say is when we talk about powers of attorneys, we'll say, "I want to get power of attorney over my
Mhm.
brother."
Okay.
And so what I want people to understand is when you are somebody's agent, that person has authorized you to do something. It's not the other way around. You do
Okay.
not go to an attorney or a doctor and say, I'm Whitney and I'm the big bad wife and I am going to have power of attorney over my husband. No.
Mhm.
Okay. That is illegal. That is not a valid document that involves coercion.
Mhm.
Instead, it is the person who wants to make the power of attorney, who needs to approach the doctors and needs to approach the attorneys and whoever else to say, I am
Mhm.
interested in making my son, Clark, my agent. Okay.
Mhm.
Because when somebody comes to me and says, I'm here to get power of attorney over my whoever, my first question is, okay, well, where is that person? And please have
Yeah.
them contact me. Because what that tells me is that you are not my client, they are,
Mhm.
potentially. And so I need to speak to them, not to you.
Okay. I like that. And so, well, let's say Lang joined us too. Hey, everyone, welcome back, Miss Whitney. Um, so in regards to power of attorney too as well, and if you guys have any questions around POA, power of attorney, we're going to hit what my dad had mentioned too as far as living will and trust, but we want to dive into the POA real quick. So if you guys have any questions of power of attorney, put it in the chat and we will definitely put it on the screen. So when it comes, I'm looking down at my questions that I have, and I know I sent them over, but I'm like, let me just make sure I get them out. So can the power of attorney overwrite a will or a trust? So can it overwrite a
Okay,
will?
so a power of attorney, it's okay. So the power of attorney operates while you are alive. The will does not.
Mhm.
The will doesn't start operating until after you pass away. So if you think about your lifespan and then thereafter, you've got like while you are alive, the several documents in estate planning that are kind of active are the power of attorney and the trust. and if you have other like guardianship designations, okay? And then once you pass away, the power of attorney stops being active for the most part. There's an asterisk there, but for the most part. And that's where the will starts. So what I'll say about, so does it conflict with the will? And if it does, what happens? No, because they don't run at the same time.
Okay.
Might it conflict with a trust? It might, because in the trust, you are giving your trustee certain powers that you might also be giving your agent in a power of attorney. Now, generally in a trust, though, those powers are going to be more specific to finances and things that are owned by the trust. So it's not really going to overlap with healthcare, but it would overlap with your financial power of attorney. Okay. And so sometimes the trustee is the same person as your agent under the financial power of attorney. Sometimes they're not the same person. And so what you do want to do is make sure that that everything is consistent across the board. So what I like to do when I'm working with clients, even if they come to me already having a power of attorney in place, I want to know what you have put, what decisions you have made, what authorizations you have made within your power of attorney, so that when we're now working on your trust, we are making consistent, decisions, so that there's not going to be that conflict. And as far as which one overrides the other, I'm really not sure. And I don't know that there's any bright line rule, unless the trust specifically says, the provisions within this trust outrule any provisions in any other document. Now, there are things in the trust that do say that, like if I want to give property to somebody, but I have another document that says the property is going elsewhere, the trust will say whether or not that the trust document is the one that should be followed. But specifically with regard to like the decisions that would be in the financial power of attorney, I'm not sure.
Okay. And so if you guys are just joining us, we're talking about, again, POAs, trust wills, and estate planning. Whitney is an attorney out of the Metro Atlanta, Georgia area. She covers the whole state of Georgia. And the reason why we're talking about this, I know people probably like, how does this go hand in hand with real estate? It does, in the sense of, if you have any real estate and you have to go, and if you're going through probate, you want to know how to effectively go through it if you're not in a trust, or if you're in a will, if you're in a POA, because some people do believe that if they have power of attorney, they can now turn around and sell somebody's house when they pass away, and you can't do that.
You can't. It does not give you the power to do that. Now, the financial power of attorney does give you the power, or you authorize someone to be able to handle your real estate. However, because the power of attorney document is only active while you are alive, when you pass away, they lose that power. And I had mentioned earlier that there was like a caveat or an asterisk with like what happens after you die. With the healthcare power of attorney or the advance directive, you can authorize your agent to continue to have access to your medical records past your death. And you would specify a time frame. And, I had not been using that power when working with my clients until recently, when I actually did a healthcare power of attorney for a family member. And that family member was diagnosed with a terminal cancer, and she later, passed away weeks later, not very long later. And now she's been gone for, I don't know, 6 months or so. And her son, well, her family, period, is having difficulty accessing her medical records because there's no authority for anyone to access her medical records. And now she cannot give authority because she's gone. And so now as a standard, I put in, my powers of my healthcare powers of attorneys that I'm doing for people, that your agent will be able to access the records for a year after your death.
Okay.
And I don't know why the family member needs it. I don't
Yeah.
know why we might need that, like in general, why we might need medical records. But there are times when it comes up. So
yeah. I don't know. Maybe they might be trying to sue, or they think that it's another reason. I don't know. You know, people be trying to. And so we kind of touched on all the POA stuff. Let's say David said, let's give the stream a little love and hit the thumbs. Yes, hit the thumbs up button, you guys, so we can get more people on the stream. It's very much needed information. Whitney is here joining us again. We appreciate her time. Whitney, this is great information and things we should know and put in place. Thank you. Yes, it definitely is. Definitely is. So now we're going to kind of shift over a little bit. I feel like hopefully, I don't know, that we kind of hit enough on the POA. I don't want people to get too confused.
Yeah. So I think maybe the one with the financial power of attorney in particular, Georgia has it broken up into 2 sets of powers. And the first set, and you'll see it on the form. So also, point to note is that Georgia has statutory power of attorney forms. If you live in other states, I don't know, but you can do a quick Google to see if your state has a statutory form. And all that means is the legislatures have agreed on a form to be used. And here in Georgia, that form requires that the person actually initial which powers they want to give their agent. And most attorneys that I know, we will just use those standard forms simply because what we don't want to happen is for us to come up with some fancy looking document that you then take to your bank and they don't know what they're looking at. Because the law just says, you know, a power of attorney needs to be in a form that is substantially similar to the statutory form. So we just use the standard statutory form and keep it moving. But so if you look at that standard form, there's one set of powers and then some words and then a second set of powers. The first set of powers is stuff like having real estate transactions, financial institutions and bank accounts, stock and bonds. So you're initialing when you want to authorize somebody to have the power to, you know, deal with those types of financial assets. The second list we refer to as the hot powers. And we refer to it as that because if these powers are given to someone and that power is abused, then you're screwed. And so they include things like being able to make or revoke or change a revocable living trust, or being able to change beneficiary designations or survivorship designations, or being able to authorize other people to be your agent. And so you can do these forms on your own. There's nothing, you do not need an attorney to do them. Where an attorney can be helpful, though, is helping you think about, if I give somebody this power, what does it mean? How might it help me? And how might it hurt me? And then an attorney is also going to talk you through, like, who should be your agent. I like to say your agent should be somebody that answers the phone. They should be somebody like not the family member who is always losing their phone, not the family member that doesn't remember their own passwords or, you know, can't manage their own money, not the family member that is currently in bankruptcy. It needs to be someone that you can trust, somebody who's reliable, and somebody that's communicative. And, you know, geographically, you might want it to be somebody who is near you, or at least somebody who lives in a city that has branches for your financial institution that they can go into if they need to.
Let's since Corey had one around POA, let's hit this and we'll jump over to the trust and wills. What age should someone consider getting a POA? I'm young and I don't plan on dying.
Amen. But you know what is certain? You will die, unfortunately. And we don't know when that's going to be. So 18. We and many estate planning attorneys like to work with parents of young adults to provide basically these college packages where, because they are turning 18, now not only is the parent dealing with empty nest syndrome and all of this stuff, their children are, leaving the home, but also the parent no longer gets access to health records, to health information, or financial information just by virtue of being a parent. Maybe you have a joint account, that's great, but you don't get that information anymore. You have to be, your child has to authorize you. And there are some 18-year-olds that don't want their parents up in their business like that. But there are some who might, because what may happen is a financial or medical emergency where a 18-year-old or 19-year-old or 20-year-old needs someone to help them make a decision, and they cannot do it on their own. In the case of my father, he was being initiated into a fraternity and wound up with alcohol poisoning and being carried home on a door. And like for days was, out of it in the hospital and stuff. And so like when in our culture, a lot of stuff happens in college, and there are times where it may be helpful for parents to have this power of attorney in place so that they can help their children make decisions. And so, but again, it would be the child who is who makes the power of attorney, and they're making the parents the agents.
The agents, okay.
So you're never too young, 18.
So you're never too young, Croy. And so we'll sift over. If you guys are just joining us, we had a conversation in the beginning about POA. So if you didn't get to see it, please rewind back to the beginning, or if you're watching it, don't forget, after we finish it, if you're recapping it, don't forget to comment below how did you get to the channel, where you're tuning in from, and please come on back. And if you have any questions for Whitney, her information will be above in the caption description below the video. And so my dad said, and we kind of dug into this a little bit last time, so I guess we can summarize it per se. What's the difference between a living will and a trust?
Yeah, so a living will is really relating to that life support question. A living will is not a last will and testament. A living will is, do you want life support? What do you want to happen if you can't make decisions for yourself and somebody else has to make decisions relating to your healthcare? A trust really doesn't talk much about healthcare at all. And a trust is really more around creating an entity that is going to hold your assets and make it easier to pass your assets after you die. It's going to make it easier for folks to be able to assist you in managing your affairs if you become incapacitated. A trust, in some cases, for the ultra wealthy, a trust is a tax savings vehicle. For some people, a trust is used to avoid tax liability, but also protect assets from creditors or from exes or from lawsuits or from Medicaid, estate recovery. So a trust does a lot of things, but doesn't really do anything relating to health. Whereas the living will is specifically regarding health.
So I have a question too, because I know somebody had mentioned this to me one time, and I might be wrong with it, in regards to if you have a trust, but you also have life insurance, there's a way, maybe we might have talked about it a little bit last time, but you don't, it's something where it's like it doesn't attach or something. I forget what someone told me about.
Yeah. So there's kind of two routes that you can go. Life insurance, first of all, even though most of us know when we have life insurance, we don't actually get to access that wealth unless we have certain types of products, like a whole life. If we have term life, maybe I have $1 million term life policy. I don't actually get any of that money, right? That money is going to my beneficiaries. So life insurance, though, is considered a part of your estate. It is considered an asset that you have. It's considered a part of your net worth. And so what this means is there might be times where you basically where your net worth matters, basically. I mean, obviously it almost always matters, but in terms of like becoming eligible for certain programs or getting certain benefits. So life insurance, though, cannot be owned by your standard revocable living trust. It can be owned by an irrevocable life insurance trust. And it's that irrevocable life insurance trust that you need if you are somebody who is trying to, I don't know, avoid tax liability, really. The federal death tax exclusion amount is 13.99 million. What that means is if your estate is over that amount, the overage is taxed at up to 40%, a very, very high rate. If you're under that amount, you're not taxed. So if you're somebody that is ultra wealthy and maybe you have, I don't know, $8 million in real estate, but then you have several $1,000,000 in life insurance, even though you wouldn't consider that your estate because you don't have access to that, everybody else does. The IRS considers it a part of your estate. So you might move your life insurance into this irrevocable life insurance trust because in that trust, it becomes a non-taxed part of your assets. Okay. But most of us don't need to worry about that. The other thing for what we do need to be considering, though, is how to use life insurance and a trust together strategically to get the death benefit to the people that we want it to go to. So how a trust can help there is, say you have that $1 million life insurance policy and you have 18-year-old kids. They can receive that full $1 million policy when you die because now they're 18. If they're under 18, they cannot receive it until they're 18. But if they're over 18 or 18, they can receive it. But maybe you do not want them to have $1 million when they're 18. Maybe you want them to have like $1,000. And then like over the course of their life, they're able to draw from it. What you can do is make your trust the primary beneficiary of your life insurance. And then your life insurance death policy will be funneled into the trust. The trustee will be managing that money and will distribute that money however you have set up within that trust. So that was a long thing, but
it's much needed information. So let's see. Link said, once a trust is established and a person dies, what happens to the assets listed in the trust and or will?
So I'll start with the will. Well, no. Okay. So if there's a trust and the assets that are funded into the trust, those assets get distributed however you have decided in your trust. Your trust you'll have decided your beneficiaries get an asset outright, or they get an asset a little bit at a time, or the trust keeps the asset and the person, the beneficiary, might get the income that the asset is creating, or the beneficiary might have a right to live in the property that the trust holds. With a will, if you have a will and don't have a trust, then you still are deciding who gets what, but you are having to go through probate court to make sure that, a judge has to authorize that transfer of the property. If you have a will and you have a trust, though, you have what's called a pour-over will. And the purpose of the pour-over will is to make sure that any assets that were not funded into the trust while you were living get treated as if they are in the trust, unless you have made other provisions for them in that pour-over will. So say you have real property because you invest in real property, but you only have your personal residence that is in your trust. The investments may not be in your trust. You pass away, everything that's in your trust it bypasses probate. You do not have to go to probate to pass things that are in your trust. Everything that is not in your trust, though, you do have to go through probate for, unless there are other ways that you've passed it. So joint tenant with right of survivorship. That is a good example. You do not have to go to probate if you own a home with somebody else as joint tenant with right of survivorship here in Georgia. But say these investment properties that you did not fund into the trust, you also did not own jointly with anybody else. You did not do a transfer on death deed. You did not. There's no other way that you've passed it.
Okay.
Now your executor has to go to probate court to tell the judge, yes, we need to probate this estate. The decedent, the deceased person, does have a trust. And so their will just says they want everything treated as if it were in the trust, except for this house. They want this investment property to go to Devon. Okay, great. So theoretically, that process should be quicker and less complicated. But anytime you're going through probate court, you are opening your estate up to creditors and claims and drama.
Okay. And it's more and more drama. So, hey, what's going on, Kevin? People's Lender. He is a mortgage lender. He serves Georgia, a couple other states as well. His YouTube channel is the People's Lender. So, if anybody has not followed Kevin on YouTube, please go over, give him a subscription, follow him, tune into his videos. Very insightful. I'm always there asking questions, and a great lender to talk to and speak with. And then also Tanya from Guided Insurance. She's a local insurance agent in Metro Atlanta area as well. I had her on a couple lives before. We're going to bring her back and talk about commercial insurance. So thank you guys for joining us tonight. If you have any questions about wills, trust, POA, probate, that's why we had Whitney here. She is a attorney out of the Metro Atlanta area, but she serves all of Georgia in regards to probates, wills, trust, estate planning. Please connect with her. Her information will be below, and we'll put up on the screen at the end too. So we'll jump into the next question that my dad had. He said, so if there's no trust in place, does that mean real estate has no, I guess we kind of already answered this, but has to go through probate?
Yeah, so just to be more direct, unless there's some other way that the real estate can pass, then yes, it has to go through probate. Other ways that real estate can pass include joint tenancy with right of survivorship. That's the language here in Georgia. I've also heard, what is it? Joint tenancy. No, I don't even know. There's other language for that same relationship. What were you going to say?
No, I said, yeah, they have different languages. They kind of interchange a lot.
Yeah, something about the entirety, like joint tenants for the entirety or something like that. I don't know.
Yeah.
All I know is Georgia. Okay, so joint tenants with right of survivorship, and then transfer on death deeds, which are now legal in Georgia, but which I do not recommend yet. In other states, they're called ladybird deeds, which is a way to pass real property without having to go through probate. And that's essentially it as far as real property. Now, there's other property that you can have beneficiary designations for. You can have payment on death designees to pass those assets without having to go through probate. So not everything has to go through probate, and you can be strategic about your estate planning so that maybe you don't think a trust is necessary. You should always have a will just in case, but maybe you're making a bunch of other decisions around how to transfer the property after your death or while you're living so that there won't be any part of your estate that needs to go through probate after you pass.
Okay. So you guys, if you're joining us live, don't be shy to ask questions. That's why we have Whitney here, and she'll answer them to the best of her knowledge. And but I do have a question. I kind of said this to you prior to us getting on live. As far as a colleague in my office, she was dealing with a probate situation. So I guess it's twofold. The first part of it, she wanted me to ask. I don't think she's on here tonight. Her name is Barbara. But the first question she wanted me to ask is,
Barbara, where you at?
I know, right? she wanted me to ask when it comes to, so her situation happened. Basically, the mom had a house. The mom passed away. They went through probate. She gave it to her. The son ended up inheriting the property per se. And then he passed away. And he has two young children. And so she was asking in regards to how does, because they didn't have a trust, as far as the will wise, how does it work with having young children in place going through that whole probate process? Because it seems like sometimes there can be some hiccups when it comes to little children being involved in that process.
Yeah, so, children under 18 really can't inherit much.
Okay.
And what ultimately ends up happening is there needs to be some kind of guardian or conservator appointed. Or sometimes if it's money, the court they'll set up a state-run trust that is going to hold that money for that child until that child is 18. And in all of those cases, the downside is that when the child turns 18, they get everything. So again, there's no like incrementally distributing anything in those kinds of like fallback options.
Okay.
So with the home, like it's if those children have a guardian, it's likely going to be a process of the guardian working with the court and a conservator and a guardian ad litem, which is a court appointed advocate for the children to figure out what to do with the home. Is this a home that the children can continue to live in and the guardian moves into the home? Is this home going to be sold? Yeah, there's a lot of questions that are going to have to be answered.
Yeah, so it's a lot with the little ones. Hey, good evening, Jaren. Thanks for joining us. And so I guess the other fold of it too is that, so she's gone through a couple. I really wish she was here to ask these questions because I feel like I'm not getting all the like nooks and crannies of it. But she's going through a couple probate situations, and she said the other day, she was like, this is the first time with this situation that she has to, I guess, give the contract for the judge to approve it. She said before, I guess they had like a leave on sale situation. So she didn't have to give them the contract to approve it. So she was like, ask her, why do I have to give the contract to the judge to approve it? She's like, that could take up time as far as selling the house.
There could be any number of reasons. I mean, I'm frankly a little surprised that she hadn't had to do that already. But maybe, I mean, if there's an executor, does she have an executor's deed?
I don't know if she said she had an executor's deed. See, that's why she was supposed to be here tonight.
Yeah, and that might be like if you
Oh.
have an executor's deed, then the executor, can do the sale. But yeah, if this is the same case involving minor children, it may be
the children, yeah.
Okay, it may be because the judge wants to make sure that the value, like the fair market value for the home is going to be, I guess, given. Because at the end of the day, this asset is for the children. And so I imagine it's just the court wanting to look out for the kids. But I don't know.
Yeah, I know exactly. I'm like, if she was here to give more insight, we just taking stuff that she told me, and I know I'm probably jacking it up too. But
how every case is different. So every case is different. Every county is different. Every judge is different.
Because you know how they say when you pass it down the line, it don't always get
right.
You don't always get safe the right way. Exactly. So if you guys have any questions again for Whitney tonight, don't be shy to put it in the comments. Again, if you're watching back on a replay, if you have any questions, put them below. But 9 times out of 10, I say it's better to reach out to Whitney. We appreciate her being here tonight. Whitney charges for this conversation, you guys. So that's why I tell people, jump on, ask some questions while you got her, because people have to they have to eat, and this is her career. So we appreciate her being here and giving us some great information for free. Hey, Miss Camilla, how you doing? Miss Camilla is a young lady that I met. She came into our real estate brokerage, and I thought this would be a great conversation with her because she asked me some questions around probate and everything like that. David said,
Mhm.
and appreciate the information. Thank you. Yes, yes. So ask some more questions, you guys. I guess I could ask you a question. Is there anything you felt like we didn't hit on last time? Because if not, I can keep asking my other little random questions that you might feel is important for people to kind of take away, like another little gem that people might want to know about.
Um, I think, like, generally speaking, I think most of us don't realize that if and when we die, like, our affairs have to be, like, wrapped up
Mm-hmm.
legally and otherwise. And so everything that you can do while you're alive to help your loved ones be able to navigate this process is going to be really helpful. And, first and foremost, there's a lot that can happen during probate. And so if that is something that you want to avoid, it requires being proactive. Um, and I think one thing that we don't talk about enough is the cost, and
Mm-hmm.
not just the cost of like my services, which I will share, but the cost of probate.
Mm-hmm.
And so when you are being proactive with your estate planning, whether or not you're hiring an attorney, you are likely not spending more than your estate would be spending to go through the probate process. So my fees for a will package here in Georgia start at $1,500. They go up to 7,000, 8,000, depending on if you need irrevocable trusts or other types of elder law planning, if you need heir property related issues. But when you are going through probate court, you can expect to spend 1% of the value of your estate up to 9% of the value of your estate,
Oh, wow.
depending on where you live. So here in Georgia, our probate courts do not have a like probate fee, which is really a tax, but it's
Okay.
some states, California, New York, Florida, you pay money just to be in court. And when I say money, I mean they charge you a percentage per every $100,000 in your estate just to be
Ooh,
there. That's
wow.
before you are paying attorneys.
Mm,
That's before you're paying for appraisals, before you're doing all the other stuff. Okay, so easily, a family could wind up spending, $10,000 just to be in probate court, if you're in one
wow.
of those states. Now, if you're in Georgia, where we don't have that fee, you're still doing things like paying for your executor to be an executor.
Mm-hmm.
You are paying attorneys. Attorneys charge, I think the most expensive that I've come across is like $600 an hour for probate. But I know attorneys that charge $8,000 for an uncontested probate, and it is just to like advise you through the process. Like they're not going to court.
Wow.
They are
Wow.
advising you on how to go through the process, and you can call them and they'll tell you how to fill out the form. But it's
Wow.
not what I think I'm spending $8,000 on,
Yeah, that's crazy.
So, so I think it's important though to talk about costs with estate planning and probate because especially our folks think that it's $300 for a will,
Yeah.
and it's not. It is not $300 for a will. Nowhere except for online.
They just take it any random
Right,
paperwork that they see
right,
online.
we think that probate is gonna be some easy thing. No, you will be billed. It will be a real bill.
Yeah. David said, "What happens if someone dies where they don't have assets, only debt? How does that work?" That's a good question.
Yeah, so the administrator of the estate or the executor is going to then have to basically prove the insolvency of the estate.
Okay.
So the debt, as long as it's individual debt of that person, is not going to be like other people are not going to be held liable for it.
So
Um,
like
but
my student loans. So like my student loans, it'll die with me.
For the most part, there are some like if you have Parent Plus loans, then they're
Okay.
your parents' loans. But
Oh
like, yeah,
dang.
or if you have loans that maybe, there's co-signers or there's joint borrowers, then, they're liable. But for most of our debt, if it's just us and now we have passed away and there is nothing, we don't have assets, then our estate is insolvent. And what happens is the creditors are still going to call your executor or administrator because they don't want you to know that you don't have to pay, because you're not the one that's indebted. So they don't want you to know that. But you will just say, you know, this is insolvent. There will still be a probate process for the court to say this is an insolvent estate, and then you will let the creditors know. And what I've been told is that the creditors won't like discharge the debt, but they are going to stop calling you. So, yeah, it just sits there forever.
So it just sits there down, and they can't do anything with it because it's nothing that.
Yeah, I mean, I guess they write it off.
Wow, that's interesting. David said, I guess that means a pretty small headstone. He's so silly. MHO 862. Oh, he changed his name. He added a 62 at the end. How does your choice? How do you choose? Or how do you choose an executor?
Yeah, this is a good question. It's a personal decision, but what I think about is what's happening when somebody is probating your estate. So one, they need time. They need time to be able to go to probate court, to figure out what they're doing, to see if they need to hire an attorney, to do the papers and submit the papers. So I think first about like job flexibility. If they are working, if they're not working, then and they're retired, then great. Just like, but time flexibility, right? The second thing is they're putting up money and then they're hoping to get reimbursed. So we talked about some of these expenses: legal fees, court fees, appraisal fees, etc. If your asset as the deceased person, if your money is frozen because you died, then your executor has to put up money to pay for all these things, right? They got to pay for all of these things, and then they're going to request the court reimburse them. So I also think about it should be somebody that has some money in the bank to be able to front, you know, these expenses. And then think about what kind of temperament that you want and what kind of estate that you're leaving. Because now, if you got babies, mamas, and if you got, you know, what is it, rent a center stuff, and if you are going to be dealing with characters, then you probably want a character yourself that is going to be representing your estate. But if your estate is going to be fairly, you know, simple, you think, then maybe it's fine to have just, I don't know, some random nice person. But think about the type of personality that might be needed to settle your affairs. Think about whether or not your estate is going to have to go through some kind of litigation, and who do you know that could handle that type of stress while grieving your death?
Enjoy. He said a mason jar for an army. Yes,
we gonna have this. Gonna be pretty. See, that's the person I just want to be. They're just gonna be shooken out over the ocean.
And so, even when it comes to an executor, let's say, what if the person before they passed, if they put in place, let's just say their best friend to be the executor of an estate and not anyone in the family?
Yeah, that's fine.
Have you ever seen anything kind of wonky with that? Do you feel like the family members would get kind of mad because they're like, why am I not the executor?
Look, I'm telling you, you do not want to be the executor.
Okay.
You do not want to be the executor. I mean, I think people think that there's like money in it or something. Like, I don't know. I don't know why people want this job. I don't want this job of being an executor. I would say too, though, that people can decline to be your executor. So don't just go willy-nilly and putting names on your could I find an executor on Craigslist? You sure could. You sure could. Talk to the person about being your executor, because, you know, people don't really want to be surprised to find out that now for the next, could be years, they're dealing with your estate. Like that, I don't want to do that.
If you guys have any more questions, we got 4 more minutes with Whitney before we have to let her go. So if you guys have any more questions in regards to trust, wills, probate, POA, which is power of attorney, put them in the chat, the live chat below. And where we're going to do, I have a question. Well, we kind of answered that. I'm just going to see in regards to the minor. We talked about revocable and irrevocable trust on the last live. So if you guys are just joining us on this live, go back to the other live that we did. We kind of Whitney dove in depth in regards to that. So I guess my David said, I thought I would find one of the chat.
He needs an executor. David's looking for an executor.
So I guess my other question would be in regards to when it comes to what was I going to say? It was something in regards to more around like the life insurance situation. Dang, I forget. This is why I should have wrote it down. In regards
I have
to
somebody who I am going to be working with called me on Friday, and I've been like researching all weekend. A father left or made a minor daughter the sole beneficiary of a life insurance policy, and the father died. The mother now is trying to get access to that policy for the daughter, and can't. And can't because the insurance company says you need like a court order that you are the guardian or conservator. And so for me, this is my first time dealing with that because I'm like, what you mean a court order talking about she a guardian? She's the mom. But because as I understand it, after talking with insurance people, and maybe I know there was one insurance person on, so maybe
Tanya,
confirm if this is how her company does this, but the client, and so the allegiance is to the decedent, the person who was insured. And so if they did not say that mom gets to access the money for the daughter, then the mom does not get to access the money for the daughter. And now what I did know is that they will hold that money for the daughter until she is 18. But I guess I just thought that, well, if there's another guardian, oh, she's driving. Okay. If there's another guardian, I thought that that guardian would be able to have that money, but no, that is not the case, it sounds like. So we're going to have to, I'm trying to figure out if I can like shortcut a guardianship or conservatorship proceeding just to get the piece of paper.
Yeah, because it's always interesting. That's why I said it's always interesting. That's why I had I know Jaren also does life insurance, but he's not replying either. She said she could email me as well if she wanted to. Yeah, it's always interesting with the insurance part of it all because the life insurance is just interesting outside of like the trust and all that stuff. Because like I said, the conversation around that is that even when it comes to I think you might have mentioned it too, as far as the state kind of taxing it and doing those type of things. I don't think they can tax the life insurance. I don't remember. Don't get me wrong with me saying the wrong things, but it's something where they can't touch something in regards to it or something. I don't know, but I'm not a lawyer, so I don't know. But it's always interesting when it comes to how things move. And like you said, as far as getting your affairs in order, and that's the whole point of the live, right? Will, POA, or total chaos. And of course, trust and, estate planning, but we don't want to be in total chaos or awry. So I guess that's really about all that I kind of had. I don't know if anybody else has any questions. I'm going to put Whitney's information below. I don't know if Whitney has anything else that she wants to say before she jumps off here. If you guys want to reach, go ahead.
I was just going to say, feel free to reach out. I'm building a mailing list of like industry professionals, folks in real estate, folks in finance, because there's a lot that we can be doing, I think, to educate each other and to build value, like as the professional in whatever industry we're in, to then be able to issue spot when somebody needs this specific type of other professional. So I'm building that type of mailing list, starting with real estate professionals and investors, to talk about like, this is what we can be talking to home buyers and sellers about. So yeah, absolutely. The People's Lender, do reach out. I would be happy to chat. I am going on vacation for 2 weeks. So if you don't hear from me, that's why. But I'll
Yes,
get
we
back
got.
to you in mid to late July.
Yeah, yes, we gotta give Whitney some time off. Like she's been busy, busy, busy. And we, like I said, we appreciate her time here. And we're gonna let her go so she can finish her packing. She got to get up out of here. He said, "How dare you, LOL." but but yes, we appreciate your time. If you guys want to reach Whitney, her email is on the screen right here. Whitney@willsforthepeoplegeorgia.com. Also, like I said, her information will be below. And if you're watching the replay and you don't, what happened? And you don't make it all the way to the end, you'll still be able to get her information below. But you need to watch the whole video and go back and watch the first video so you can get more of the context. But again, thank you, Whitney, for joining us tonight. Thank you, everybody, for coming and being a part of this live chat. And I don't know if you have any last words to say before we head out of here.
No, thank you. Thanks for having me, Devon. And it was nice seeing you all again.
Yeah, no problem. All right, you guys, have a good night. Bye-bye.
Bye.